Daubert versus Merrill Dow Pharmaceuticals is a well-known case that changed the playing field for opinion evidence since its publication by the U.S. Supreme Court in 1993. Daubert and its progeny are federal cases, but approximately 40 states generally follow the federal rules of evidence regarding opinion testimony. In this video, I'll give a brief overview of the history of the admission of opinion evidence. I'll summarize the three cases composing the Daubert trilogy, and I'll share concerns and opportunities for financial experts to defend against Daubert challenges, and finally, how to use the holdings of the Daubert trilogy and subsequent case law to the expert's advantage when dealing with clients. Here's a quick history of the admissibility of expert testimony. In 1923, a defendant named Fry was convicted of second-degree murder in the District of Columbia. At his trial, he sought to admit expert testimony on the results of a systolic blood pressure test, later known as a lie detector test. The expert testimony was objected to by the government, and the trial court excluded the testimony from his trial. On appeal, the District of Columbia Court of Appeals affirmed the lower court's decision, stating, "Courts will go a long way in admitting expert testimony, deduced from a well-recognized scientific principle or discovery. But the thing from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs." This was the beginning of the Fry general acceptance test that survived unchallenged for 50 years. Then, in 1972, Congress adopted Federal Rule of Evidence 702 stating, "If scientific, technical, or other specialized knowledge will assist the trier of fact, a witness qualified as an expert may testify in the form of an opinion." Federal Rule 702 provided additional guidance, but it didn't specifically overrule the Fry general acceptance test, so there was still some confusion in the federal courts. So along comes Daubert versus Merrill Dow Pharmaceuticals in 1993. I'll just touch on the unfortunate facts of the case because they aren't important to the evidentiary holding, which is what we're really focused on. Plaintiff children claimed that their serious birth defects were caused by their mothers taking the anti-nausea drug Bendectin during pregnancy. At trial, plaintiffs proffered 8 scientific experts who performed various analyses and reanalyses of existing studies, mostly animal studies apparently, regarding the drug. The experts concluded that the drug caused the birth defects in the children. The trial court excluded the experts' testimony because the methodology was not generally accepted. On appeal to the Ninth Circuit Court of Appeals, the trial court's exclusion was upheld for the same reason. The scientific analysis was not generally accepted. The United States Supreme Court granted certiorari, quote, "in light of sharp divisions among the courts regarding the admission of expert testimony." Here's a summary of the holdings in the Daubert decision. Number 1, Federal Rule of Evidence 702 controls admission of opinion testimony and it supersedes Fry's general acceptance standard. 2, the trial court is the gatekeeper of the admission of expert evidence, not the fact finder. Number 3, to be admitted, evidence must be both reliable and relevant, as implicitly stated in Rule 702. The Daubert case also proposed 4 factors to help a trial court determine reliability. The factors are, has the theory been tested? Number 2, has the theory been subject to peer review? 3, what is the known error rate of the testing? And 4, is the theory generally accepted? On the question of relevance, will the evidence assist the trier of fact in deciding some fact of consequence? Now, the confusion with Daubert is that it's related to scientific testimony. Therefore, the 4 reliability factors don't exactly fit into financial analysis and testimony. So focusing on the Daubert factors, which is what most commentators talk about, isn't exactly applicable to us, financial experts. The second case in the Daubert trilogy came in 1997, General Electric v. Joyner. Joyner is really a procedural case, holding that a trial court's decision to exclude or allow opinion testimony can only be reviewed for abuse of discretion. Abuse of discretion is a very high standard of review. That means a trial court's decision on admissibility can only be reversed if it violates a standard that no reasonable person would conclude what the trial court concluded. So as a practical matter, that's not going to happen. The trial court probably won't be overruled. Its decision is final. One very good quote from Joyner that might be applicable to a financial expert is this: "Trained experts commonly extrapolate from existing data, but nothing in either Daubert or the federal rules of evidence requires a district court to admit opinion evidence that is connected to the existing data only by the ipse dixit of the expert. That means only by the say-so of the expert. A court may conclude that there is simply too great an analytic gap between the data and the opinion proffered." Although Joyner didn't involve financial issues, this comment in Joyner is the area in financial expert testimony that I think we need to be the most careful of: the possible gap between what we're analyzing, comparable sales, projections, the subject company's industry, the industry growth, discount rates, price earnings multiples, etc., and the subject business we're looking at. Be very careful of the possible gaps in the connection between our subject business and these external benchmarks. This is where a court can decide your testimony isn't reliable. The expert has stretched too far. The last of the Daubert trilogy comes in 1999, Kumho Tire versus Carmichael. Another set of sad facts: a tire blowout case that killed one passenger and seriously injured other family members in the vehicle. The plaintiffs offered expert testimony of an engineer who evaluated the tire involved in the accident, and he concluded that a manufacturing defect caused the blowout. The trial court excluded the testimony because it found insufficient indications of the expert's methodology. The 11th Circuit reversed, believing that the Daubert factors only applied to scientific testimony. On appeal, the U.S. Supreme Court concluded, the Daubert gatekeeping obligation applies not only to scientific testimony, but to all expert testimony. Okay, forensic accountants and economists, welcome to the club. We're in. Daubert applies to us. Kumho reminds us that the Daubert factors don't constitute a definitive checklist or test, and the gatekeeping inquiry must be tied to the particular facts. Daubert's gatekeeping requirement is, quote, to make certain that an expert employs in the courtroom the same level of intellectual rigor that characterizes the practice of an expert in the relevant field. Another quote from Kumho: the trial judge has considerable leeway in deciding how to go about determining whether particular expert testimony is reliable. So those are the three big cases, and here's the quick summary of the Daubert trilogy. 1. Federal Rule of Evidence 702 is the statute controlling the admissibility of opinion evidence, not the common law theory of general acceptance. The standard for admissibility is reliability and relevance. Number 3. The trial court is the gatekeeper for admissibility. It's not the fact finder, that's the jury's job. Number 4. The trial court will only be reversed for abuse of discretion, a very high standard. The Daubert trilogy applies to all expert testimony, not just scientific testimony. I've traced the Daubert trilogy forward to the present time, and as it concerns financial experts, I'll share the ways courts have excluded financial evidence based on lack of reliability or relevance. First, the calculations are speculative, or they rely on speculative projections and are therefore unreliable. Examples of this flaw are unsupported business plan projections, or projections too far into the future, or projections that are merely aspirational hopes of management. How can you overcome the speculative flaws? Establish research and other rationale to support your assumptions. Find as many ways as possible to confirm and validate an assumption, and hopefully you can find a financial way to correlate the projection assumption to some objective benchmark. And consider using the final item of support as It simply makes sense. Now, that last one is never enough in and of itself, but as a final item of rationale, it's okay as long as it's true. Another common flaw is insufficient facts or data to support a necessary step in the analysis, leading to unreliability. Examples of this problem are unsubstantiated estimates, reliance only on a client representation of some fact, relying on deposition testimony of a related or interested party. These are examples where courts find insufficient facts or data, leading to a conclusion of lack of reliability. How can these weaknesses be overcome? By drilling down on your analysis and making sure that you cover as many bases as possible with confirming research and investigation on your underlying steps, confirming client representations with financial documentation of underlying facts. Don't just accept a blind assertion and adopt it as a basis for your analysis. Here's another flaw that's led to exclusion of testimony on the grounds of relevance. Too wide an analytic gap between the subject and the external research. Examples of this weakness are comparing a small company to giant companies for purposes of supposed comparable analysis, drawing careless conclusions about a company's industry or growth of an industry, and blindly concluding that these external statistics apply to the subject. The remedy for this type of reliability error is care and judgment in your comparisons. Recognize the lack of comparability when you see it. Use your head first and make adjustments, if possible, for these differences. Finally, there are some simple, obvious mistakes that will get an expert excluded at the gatekeeper level. These two are for relevance. One is failing to revise calculations after facts have changed. Easy remedy there. Or number two, calculating damages for a cause of action that has been removed from the case. Make sure your work conforms to the pleading theories of the case. In summary, I think there are some very good things for financial experts about the Daubert trilogy and its progeny, even though most experts fear the Daubert challenge. My research indicates that only about 40% of Daubert challenges are successful, so your chance of winning is 1.5 times greater than losing, at worst. And your odds increase significantly if you're doing good work, which I hope and expect you are. After Daubert, the standards for admissibility have definitely been raised. You can use this fact to help keep your clients in line with their requests of you, particularly unreasonable requests. Using Daubert affirmatively affords you the opportunity to defend your reasonable analysis and assumptions to your own clients when they're pushing you to stretch your analysis and opinions. I've worked in the real world for 40 years, and I know that happens. On the other side of these cases, opposing lawyers will always try to argue against you, and they'll often make strained interpretations of points that go against your analyses. Welcome to litigation. If you stayed within your area of expertise, used reliable methodologies, and made well-researched assumptions and estimates, that's your response to Daubert challenges and arguments against you. Following those guidelines, you'll do fine as a financial expert witness in litigation for many years to come. I hope my perspective assists you in building and growing your forensic consulting practice. My treatise, Mastering the Art of Expert Witness Testimony, summarizes my experience managing and operating a successful forensic consulting firm for 40 years. It's available on Amazon, and I assure you it's worth your time.
Brian Peter Brennig is an adjunct professor at the University of San Diego School of Law and managing director of the forensic consulting group of CBIZ, a national financial services firm. The strategies and tactics presented in this video presentation are discussed in complete detail in his treatise, Mastering the Art of Expert Witness Testimony, which is available by scanning the QR code on the screen or on Amazon.